90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is Attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. Our guest today is Joanna C. David. She's a partner in the Long Island law firm of Forchelli, Deegan, and Terrana, and she is with the Tax, Trust, and Estate Department, and she's going to talk about the do's and don'ts of estate planning. Joanna, welcome to Law You Should Know.
Thank you, Ken. I appreciate you having me on the show.
And I realize there are people in many different situations, but what are some important things that everyone needs to know about estate planning or the basics of estate planning?
Sure, absolutely. The first thing that I would say people need to know is that everyone needs a plan, right? I think that many times people think that, hey, I don't really have many assets, I don't need to plan, I don't have anything. But on the contrary, everyone needs a plan. At the very least, everyone needs a will that disposes of assets upon, their passing. A power of attorney is very important, Ken, and a healthcare proxy. A power of attorney is a document that would allow your agent to handle your affairs in the event that you were incapacitated. And a healthcare proxy is a document that would allow your agent to make medical decisions for you in the event that you cannot make medical decisions on your own. So those are very important documents, at the very least, that everyone needs.
And the power of attorney and the healthcare proxy, if you're unable to act for yourself, it would be a very expensive and cumbersome proceeding to go to court, to have the court appoint someone to act for you, and you can simplify it and save money by giving authority to those people in advance when you're competent to do so.
Absolutely. Absolutely. A guardianship proceeding is not a nice proceeding, Ken. It's very expensive and very time consuming. So save yourself and your family the headache and just plan ahead.
And sometimes families contest those things. So this way you're doing it your way.
Exactly.
And the will is just the opposite. The will doesn't even come into being until you pass on.
That's right.
But again, by having a will, you're doing it your way. It can prevent battles and extra legal proceedings that can be very costly and bitter.
Absolutely. Absolutely. You get to put down your wishes and say what it is that you want. So definitely, I agree.
And if you don't have a will, New York State has a plan for you.
That's
by
correct.
default, and you may not agree with that plan.
That is correct. I always tell people, listen, if you don't write a will, New York State will write one for you.
And has a will for you.
Absolutely.
And also, with a will, you can appoint people to act on your behalf once you've passed on, and it's really your choice. If you don't appoint those people, the state or the surrogate might appoint people, and it can be expensive, time-consuming, and people may not be happy.
That's right.
So with your will, it's your way.
Correct. I like that. I like that. I think I'm going to coin that, Ken, if that's okay.
Absolutely. And unfortunately, it's true. So what are some of the basic things that someone can do with a will, whether they're rich or poor, whether they have a lot of stuff or millions of dollars?
Sure. So with a will, the first thing you want to do is you want to appoint an executor, right? Who is going to be in charge upon my passing? And also don't make the mistake of not appointing a successor executor. I can't tell you how many wills I've seen where, someone just appoints one person. And then that person passes away or that person is unwilling to serve at the time. So definitely think about who's going to be in charge. Think about a backup, maybe even two, and, to have that in place. In addition, you want to consider an important thing to consider if you have minor children. Who is going to be the guardian for your minor children in the event that you pass away? Another very important part of your will that should be there. Other than that, I would say that you can dispose of your assets as you wish. Maybe you have some personal items that you want to dispose of in your will, your wedding ring or, a family heirloom. And then, of course, we know that there's cash and real property as well that you can dispose of.
And one thing also people may not realize about wills is it's good to look at them, update them, revise them as necessary. Your family tree may change.
Yes.
There may be new relatives, new grandchildren. There may be people who've passed on. There may be people you want to disinherit.
Correct.
Within the provisions of law. So you want to revisit that to make sure it also considers the latest tax laws and your current wishes.
That's correct. We always tell clients that you should at least look at your estate plan about every 5 years or so. Right. And of course, especially if there is a change, like you said, in family, if there's a wedding, a divorce, a baby, something like that, you definitely want to take a look at your estate plan.
And as you mentioned before, it's always good to have a backup. People act for you. The executor is someone who you appoint to handle your affairs after you've passed on.
Correct.
And of course, they can engage a lawyer if they need to. They don't just have to be someone responsible who's going to know your wishes.
That's right.
And if you don't appoint someone, the court will name someone that may not be the person you would want to serve for you.
That's right. That's correct.
And people move away. People are unable to do it. So that's why it's important to name a couple of people and then update your will if those people are no longer available.
That's right. Life happens. There are circumstances where, again, family and friends move away or they pass away, or maybe you're just simply not close to whomever you appointed, like you once were when you wrote your will, when you signed your will, rather. So absolutely.
And is there some property that generally passes on by its own terms and people should update beneficiaries to insurance policies or pension plans or other assets they may have?
Yes, absolutely as well. That's correct. Anything that has a beneficiary will pass outside of the will. And I think that a lot of people tend to maybe don't understand that or forget that. Some people just don't know. So if you have a beneficiary on, an asset, like you said, like a life insurance policy or something like that.
Even, let's say, a savings account.
Or a savings account, yeah. That passes outside of your will. So, sometimes people come to me and say, hey, mom or dad left a will. It says everything 50-50. And I say, okay, great. Well, what's in the estate? Well, there's a joint account with my sister. There's XYZ with the beneficiary. And I say, well, those assets go directly to those individuals, right? And then the client says, but wait a minute, the will says 50-50. Unfortunately, it doesn't matter. The will only cover assets in your name alone at the time of your death.
So where something has a beneficiary who's still alive or it's in trust for someone, maybe there are two names on the account, those things will pass automatically if you pass on, and they don't pass under the will. The will's going to direct the property in your estate where there are no beneficiaries.
Correct. Property in your name alone at the time of your death.
So is it good to have another name on your account?
Well, it depends. It depends on whether you trust that person, right? I mean, in the case of husband and wife, you see that happen a lot, or in the case where there's a caretaker child, maybe. So, the answer is it depends, right? The lawyerly answer is it depends. Sometimes a client just has a small amount, or they say, listen, if this amount goes to this person, such as my son or my daughter, I'm okay with it. And other times clients say to me, listen, I want to have a joint owner, and this child I understand that they're not legally bound, but I trust my child and they understand I want them to share these assets.
And you could also set up separate accounts with different
Sure.
children as beneficiaries for different accounts. And again, the beneficiary, they can't touch your money until something happens, till you pass on.
That's correct. But be careful, Ken, because that's not with a joint owner, right? A joint owner.
And I just want to bring that out.
Right.
Yes. So a joint owner can go in tomorrow and perhaps take all of it.
Right.
When you don't want them to. So you just want to be aware of that. Because if you want to have control, you may want to be the only person on it. But then again, if you're disabled, you need someone to pay your bills, or it's a spouse, just understand what joint ownership means, and they probably get the whole thing if something happens to you.
That's correct. And I tell clients, listen, the safer option, right? Because look, people don't pass away in the right order, right? And things happen. We don't have a crystal ball. So I would say that the safer option is to make sure that you have that power of attorney that we talked about, right? Opposed to putting a joint owner on. So the power of attorney is going to be able to take that document to the bank and to use that to pay your bills or to handle your affairs.
And essentially, it's while you're alive, but maybe it's not convenient for you, or maybe you're disabled, they can act for you.
Correct.
Within the context of the power of attorney, within the scope of it.
Correct. And a power of attorney, like you said, will die with you. Okay. So, it's important to have beneficiaries on your accounts. However, understand that a power of attorney is not a beneficiary. It's not a joint holder. It's simply someone that can act on your behalf in the event that you cannot do so on your own.
And your account, you can probably change beneficiaries if someone passes on, and they don't have control of the money until you pass on.
Of course. The person doesn't collect until you've passed away.
And with something like a pension, is it good, or a life insurance policy, is it good to have beneficiaries on something like that?
Yes, definitely. A lot of times with pensions, depending on the option that you choose, right, you can take less, and maybe your spouse can have a pension for their lives or whatever have you. Life insurance policies, 100% yes. Please put a beneficiary on your life insurance policy. Put a primary, put a secondary. That is very important.
And change them if necessary. If the beneficiaries
if
they're no longer part of your family, you no longer want them to get it, change it.
Yes, and I just like to make a quick point as well, Ken. A lot of people tell me, I have minor children or minor grandchildren as beneficiaries. Big red flag, big no-no. Please don't put your minor children as beneficiaries because they're not going to be able to collect the account, right? Essentially, the account will be frozen until they're of age. There's going to have to be a guardian for them in order to be able to collect the money. It's a mess. So don't put minor children on your bank account if you can avoid that.
And what about provisions? You want to provide something in your will. What if the children are minors? What is the better practice, the better way to do that to make sure money or part of your estate goes to them?
Sure. So, we can create trusts in wills. It's called a testamentary trust, where your will say, for example, everything to my children or XYZ to my children in trust until they are the age of, and you pick your age. So, for example, I like to pick 30 because that's when, a lot of people can handle assets, or 25 at least.
They're not going to go spend all the money on a car or
on
something.
A Lamborghini, yeah. Exactly. So, you can say that in your will, right? That the assets are held in trust for them. Money can be used for health, education, maintenance, or support. And then upon that child attaining the age that you have stated, so 25 or 30 or 35, whatever you choose, then they get their distribution.
And there also would be a trustee, someone you select administering that trust.
Correct.
Who might have the power to deviate a little bit if the need arises.
That is correct. The trustee is going to be in charge. Again, we want to make sure that we have a primary trustee and a successor as well in case something happens to that first person. Yes.
I'd just like to remind our listeners that we're talking about do's and don'ts of estate planning, the very small estate or a very much larger one. Our guest is Attorney Joanna C. David. She's a partner in the Long Island law firm of Forchelli, Deegan, and Terrana, with offices in Uniondale. And you're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College in Garden City, Long Island. Keep in mind, whatever we're saying is presented for information only, and you should only make estate advice or will advice based on advice for you from a lawyer. And if you missed any portion of the podcast or you want to tell someone else about it, just go to the website, nccradio.org. What are some other things that someone can do with a will? As you mentioned before, with a will, it's their way. There's no ambiguity, and their wishes will be carried out.
Sure. A common provision in a will is what we call the no contest clause, and or an interim clause. And basically it says, hey, if anyone contests this will, in any way, then they will forfeit their share. So that's a common clause that we see in wills, especially in situations where maybe the distribution is not equal, right, to the children, or it deviates from what the law would provide. So maybe you're leaving assets to grandchildren or in unequal amounts. A lot of times we see a no contest clause in wills.
And contests can be very expensive and very hard emotionally on the entire family.
Absolutely. They're very expensive. They can take time. And a lot of times it's unfortunate, but contests can drain an estate.
And that's all the more reason to make a will, consult with an attorney about the pros and cons and different ways of protecting your relatives or your children and passing things on to them. And because there may be different options.
That's correct. And I would say, Ken, it's important to, the very first, I would say, don't of estate planning is, don't go to an attorney, rather, that does not specialize in this area of law. And here's why I say that, right? It's a very niche area, a very nuanced area. There are a lot of things to know, and it's not one size fits all. So make sure that you're going to someone that knows what they're doing, that can guide you properly. I give my clients the example, if you have a heart problem, you go to your cardiologist, right? You don't go to your podiatrist or to your dentist. So it's the same thing when it comes to trust and estates and estate planning. Find an estate planning attorney that can help you plan properly for your particular circumstance. As we get into a little bit, of complicated or complex estate planning, we start to talk about trust, living trust. And that's something that can help to even avoid a court proceeding altogether. And again, you're going to want the expertise of an estate planning attorney to help you navigate those waters, right?
And just explain what a trust is.
Sure. So a trust is a document. It's a vehicle that holds assets or holds property. A trust will avoid probate upon your passing, and probate is a court proceeding. So if you have just a will, upon your passing, a lot of people are shocked when I tell them a will is not automatic, okay? To my kids in equal shares, that's it. Not exactly. You still have to submit that will to court, and a judge has to confirm that it was properly executed and appoint the executors, right? A trust, again, is a document where you avoid the probate process. So you can put assets into a trust, like your home, for example, right? And it will avoid the court proceeding, and it will divide your assets that will pass seamlessly to your beneficiaries upon your death.
And there could be favorable tax consequences as well with some kind of trust.
Indeed. There are several different kinds of trust, and it depends on what the client's goals are.
And sometimes people are concerned about availability of Medicaid, and
Correct.
Trust might be another tool for setting up an entitlement to that.
That's correct. Trust can shelter assets, can help clients to become Medicaid eligible if they're looking for some sort of home care or nursing home care down the line. There are several different kinds of trusts. Those trusts are usually irrevocable, but there are also revocable trusts where it avoids probate upon passing, especially if a client has assets in more than one state.
Right, so you just want to understand the consequences of whatever you're doing, and you can always sit down with the client and explain it to them. Because if it's irrevocable, it may mean you can't change it except under certain circumstances.
Correct, absolutely. But there's a lot out there. There's a lot in this area of law, and it's important for clients to get what fits them. And again, you want to go to somebody who practices and who's well versed in this area of law. I can't tell you how many times clients have come to me with documents, that were not properly executed or that was missing very important provisions for their goals.
And that's the idea, that it's better spending some money to have a lawyer draft the will,
Right.
supervise its execution, than printing something off the internet, which might not contain the proper language.
Absolutely.
A will has to be witnessed. There's other procedures that have to be done with it.
Other formalities,
because if it's not done properly, it's a worthless piece of paper. And the idea is to make sure that your will be carried out, and that only happens if it's properly executed, and I would say preserved. So if there's someone, if you find a will, you find someone's will, don't start writing on it, on stapling it.
Yes,
damage
please
it in
don't
any
do
way,
that. Yes,
because the court's not going to know who did it.
Right.
And it might taint it.
Correct.
And there's also a formal execution process for wills. Can you just explain that briefly to make sure that the person who's writing the will, to make sure it's actually their wishes and their will?
Sure, absolutely. So whenever I'm executing a will, I explain the will. I go through the will with the client. And then there are a series of questions that we have to ask, right? So I ask them, do you understand the terms of your will? Do you declare, right? Because you have to declare, you have to publish that this is your will. Do you declare this is your will? And finally, do you ask us, usually myself, my paralegal, my legal assistant, do you ask us to witness this will? To which the client has to respond, yes, I do.
And the point I'm making is it has to be properly signed, or
Correct.
it may not be a valid will.
That's correct.
And that's something you'll handle as part of the process.
Yes, it has to be signed. And again, it's important for all of these documents to be properly signed and witnessed and notarized. I mean, some of these documents that we're discussing, power of attorney, healthcare proxy, it's very unfortunate. But I've seen people who unfortunately are incapacitated, and the family member comes to me and says, hey, I have a power of attorney. I say, hey, okay, great. Let me see a copy. And then there's only one witness, or it's not notarized.
And the power of attorney, the healthcare proxy, and even the will have to be signed by the person while they're competent to do so.
Correct.
If they're already incompetent, they've had a stroke, maybe they have Alzheimer's, they may no longer be competent to sign those documents. So it's got to be done before those things happen.
Right. And also, I just would like to make the point that, and I agree with you 100%, Ken, sometimes on the flip side, just because someone may have had a diagnosis or may have had a stroke, it doesn't necessarily mean that you don't have capacity to sign these documents. So on the flip side, sometimes people say, oh, she had a stroke, she can't, sign anything. That's not always the case. So again, get the right advice from an attorney.
Oh, yes, you can advise them whether the person is capable and make sure there's backup to it, so that the will be valid and will be carried out. And there might be ways to do it, videotape, a doctor's affidavit, whatever it is.
Right. So, not necessarily a videotape on my side, but I have, had, clients get a letter from their doctor saying this person can handle their decisions. They are competent to make a will. I've had that happen before. I've done that before and kept it in my file, especially if I think that one of the family members or someone that might be entitled to something under the will, right, to distribution, a distributee, if I feel like they're litigious, I may have that in my back pocket.
And you never know when disaster can strike. So it's better to execute that will and these other documents when you're physically and mentally able to do so.
Correct. It's always better to do them sooner rather than later. A common myth, I like to talk about myths a lot about estate planning, is that once you sign these documents, you're giving up everything. People say to me all the time, I don't want to sign a healthcare proxy or a power of attorney because that means I no longer have access to my own affairs. I'm not in charge of my life anymore. And I say that's not true. To the contrary, you're still in charge of your affairs. You are allowing somebody else to take over in the event that you become incapacitated. So I think that that's very important for our listeners to know.
And while you're capacitated, you can revise any of these documents.
Of course.
The will, the healthcare proxy, or the power of attorney. You can change the beneficiaries.
At any time.
You can revise their scope while you're competent to do so. So you're not locked into it.
Correct. You can change them at any time.
But if you don't have them, you may be locked into whatever the court does.
Correct.
I just would like to remind our listeners we're talking with Joanna C. David. She's a partner in the Long Island law firm of Forchelli, Deegan, and Terrana, with offices in Uniondale. And she is a partner in the Tax, Trust, and Estate Department. And I just want to remind you further, whatever you've heard is being presented as information only. You must get legal advice for your particular situation from a qualified attorney or other professional. And if you missed any part of the program, you can find the podcast at nccradio.org. And you're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College in Garden City, New York. What are the final do's and don'ts and guidance do you have for your clients and our listeners about estate planning?
Sure. So, and thank you for that, Ken. Again, do get get an estate planning professional. Don't take anything for granted. None of us have a crystal ball. Don't print documents online. Do revisit your estate plan every few years, or if there has been a change in your life circumstances, for sure, please do that. And also, in the event that you have other accounts, several accounts, and life insurance, do put beneficiaries on those assets, and definitely don't put minors as beneficiaries on your account.
And try to update those beneficiaries as the need arises. And once you have a will, take care of that document. It's a very important legal document. Can you give us the website of your firm where you presumably have other information about this?
Sure. You can visit us at forchellilaw.com. That's FORCHELLI law, LAW.com. We are a full-service law firm here on Long Island, and our listeners can get more information about what we do at Forchelli, as well as information on estate planning and hot topics coming up in the trust and estates and estate planning world.
And you can recommend a suitable will and estate plan for someone of limited means, someone who has a house, someone who has much more,
Correct.
Assets, businesses. There's different wills and different devices for different situations.
Yes, there are definitely different estate plans for different situations. At Forchelli Law, we service all clients, whether you have limited means or whether you are very, very wealthy and you have multi-millions. There is an estate plan for you, and don't make the mistake of not having a plan in place. And if you are very, very wealthy, there are things that we can do to reduce taxes, to limit exposure, shelter assets, and so many other things.
And what other services does Forchelli, Deegan, and Terrana provide to the Long Island community?
Absolutely.
What other departments do you have?
Sure. We have a corporate department. We have a land use and zoning department. We have a real estate department as well. We have a bustling tax cert department that is only growing at Forchelli, and so many other areas of law. Those are some of our main areas that we practice.
And the tax cert department is an ever busy area.
Ever busy area, yes, and it continues to grow.
And I would like to thank our guest, Joanna David of Forchelli, Deegan, and Terrana, for being our guest on Law You Should Know. Please remember you can listen to the podcast at nccradio.org, and it's presented as information only. And please join us next week at the same time here on 90.3 WHPC, the voice of Nassau Community College, for another program on Law You Should Know.